Okay, welcome everyone. This is Barbara Rowling of Comerica Bank introducing our speakers for the Environmental Bankers Association's webinar on navigating environmental risk during foreclosures. But first, we want to make sure you're aware that the EBA makes no warranties about the accuracy or suitability of the information provided in our webinars, and they are not intended to constitute advice or consultancy of any kind, and the opinions expressed may not necessarily represent the views of the EBA. Our speakers today are Craig Welin, an attorney for Frandzel Robins Bloom Csato, based in Los Angeles, California, who will be providing an insight from a California perspective on foreclosure law. Chuck Serafino is a shareholder at Vincent, Serafino, Geary, Waddell, and Jenevein, based in Dallas, Texas, and he'll be giving a view of Texas foreclosure law. And last but not least, Keith Maruska, First Vice President and the Real Estate Officer of Comerica Bank, and my colleague will be moderating and providing a 30,000-foot view from a bank's perspective. More details on speakers' respective practices and experiences will be at the back of the slide presentation. I did want to mention that the EBA will be having a presentation on secured creditors exemption related to foreclosures during our virtual conference, which is being held on the 22nd and 23rd of June, and it's available free to all EBA members. So this is a really good opportunity to become a member and take advantage of this free seminar or conference. You'll be able to join online at the EBA website or from the link sent to all registered EBA members. Also, attendees will be muted during this presentation, but we'll be taking questions throughout the presentation in the chat box in the control panel on the screen. The questions will be collected, and after the presentation, Georgina Dannett of Bank of the West will be directing the questions to our panelists. Finally, this presentation will be available on the EBA website on the Events tab under EBA Online Seminar Series. And with that, I'm going to hand it over to Keith to begin the dialogue.
Excellent. Thank you, Barbara. Welcome, everybody. Crazy times we're living in. I'm sure my world will get busier in the coming months. But today's talk is going to be mostly just about foreclosure practices, procedures, kind of how that in some cases relates into the environmental world, decisions lenders need to make and kind of issues that are in front of them when considering foreclosure. Outline for today, we're going to talk about the defaults, loan defaults, and things that lead to a bank's, in some cases, need or desire to foreclose to get paid back. Resolution alternatives, I can tell you Comerica Bank would probably rather never foreclose. That's just not realistic. It's going to need to happen. But there are, in some cases, other alternatives that are better. Talk about that a little bit. We'll talk about the different types of foreclosures in Texas and California. In some states, there are only judicial foreclosures, but Texas and California have both. We'll talk about the differences in the timing and some of that. Foreclosure considerations, we'll look at, different things that come into play as to whether you really do want to own a property. Sometimes related environmental, physical conditions, how delinquent are the property taxes, if there's a bankruptcy filed, what can you do, those kind of things. And then also reinstatement going into a foreclosure, the time frame, how late can a loan be reinstated, depending on the type of loan and the documents, is reinstatement possible, and the timing of that. And then also the foreclosure sale bid or the credit bid by the lender, the considerations that go into what you're bidding, and in some of the states there are different laws that pertain to that as to what you're bidding in and also what you book it in at, which are two separate issues. And then redemption rights, what happens during a redemption and what states have redemption, what types of foreclosures have redemptions, that kind of stuff we're going to end up with. But I also want to bring up that everything we're going to talk about is related to commercial loan foreclosures. None of this stuff that we're talking about is residential mortgages that have CFPB, Consumer Finance Protection Bureau regulations. It's all related to commercial loans that we don't have those regulations to deal with. And also we're gonna have to keep this moving. It's 1 hour presentation with probably 4 hours of material and just talk about Texas and California. So there is a need to move pretty briefly through these slides. We're also going to try to bring in some real world scenarios, some hypothetical, and I'm going to have Craig just kind of discuss some of the background on a hypothetical that we'll try to weave into the discussion at points today. We've got 2 slides of that. Craig, do you want to have a few words about our hypothetical?
Sure. Thank you, Keith. This is Craig Welin speaking to you from sunny and soon to be reopened, we hope, Southern California. What we've tried to do here is create a hypothetical that provides a little humor and also gives you sort of a real world example and puts some of the issues that we're going to talk about into context. In our hypothetical, which is up on the screen, you can see that Bank of the Pandemic has acquired another bank's loan portfolio. And of course, Bank of Pandemic in these trying times didn't bother to do any due diligence on its acquisition of this portfolio. One of the loans in the portfolio, the borrower is by the name of Lucky Borrower, and he has 2 loans in that portfolio, one in Texas and one in California. Lucky Borrower isn't a California limited liability company that has 2 members, I Be Rich and I Am Not So Rich, each of whom have personally guaranteed the borrower's obligations. The Texas loan is in the sum of $10 million and is secured by a retail center with an empty field next to it that used to have a gas station that has long since been basically destroyed. And then the California loan is secured by an office complex with a principal sum of about $22 million. As seems to be the case these days, each of the loans have gone into default, and the borrowers are claiming that for a variety of reasons, presumably the pandemic in most instances, they cannot make the payments on the loans at this time. And so they're looking to the bank to help them out. So that should give you sort of a little bit of background on how we're going to make this work today. And with that, Keith, I turn it back to you.
Okay, so just generally, the reason a bank or lender may want to foreclose is to collect money because of a loan default. And there are different types of defaults, different things to consider, and it really is a function of what's in the loan documents. But Chuck, do you want to talk a little bit about loan defaults and what can lead to a foreclosure and some of the issues that come into play?
Sure, absolutely. And this is Chuck Serafino from partially shut down Dallas, Texas. Welcome everybody this afternoon. We're talking only commercial. As most of you know, with consumer defaults, that is an absolute minefield of disclosures and how you handle it. So that's a seminar in and of itself. So we're going to stay away from that. But when you're looking into defaults, the first place you always look are your loan documents. That's the roadmap, which tells you what you can and cannot do. And that would include your note, deed of trust, any side letter agreements, and any other security agreements. When you're looking at defaults, a monetary default is obviously a material default, and that's what we have in most cases, and that typically prompts the bank to act. However, there are all sorts of non-monetary defaults and covenant defaults. Most of these, a default's a default. You can act on it. You can start liquidating collateral, do anything you want. But we tend to urge most of our clients, if it's not a material default, you do not want to take a material action unless it's just a loan you want to move out or you need to put other pressure on the borrower. Just moving on a little bit on that, there is a bit of a minefield on where you as a loan officer can get sued and your bank gets sued if you don't do some checking first when you're looking into a default. That's primarily checking to see if any of your obligors, your borrower or guarantor, has filed for bankruptcy. If they have, there's an automatic stay in place on any collections or demands against them. Those things get you in trouble. The other is looking for military service on the website from the federal government, and that's under the Service Members Act. We are technically at war with what's going on in Afghanistan and the Middle East, and if one of your guarantors on a commercial loan is on active duty and you send them a demand and start trying to collect, or you try to collect collateral that guarantor has pledged, then you can get sued. And that has happened. I have a couple of clients where that's happened to, where a service member is on active duty. They see some collateral that he had pledged to guarantee a commercial loan, and next thing you know, you bought a lawsuit. So there's just things you want to make sure that you're complying with your loan documents, you're doing your research before you commence.
Yeah, I mean, just one thing on that. Part of it is the upfront, all the loan agreement, the doc review by a good qualified foreclosure attorney. That's very important and certainly can keep you out of trouble. Resolution alternatives. Again, I mentioned Comerica would rather not own property, would rather never foreclose, certainly rather not advertise that we have to foreclose. There's often, and I would say more often than not, there's other alternatives that can jump into play. Craig, do you want to mention a few that you've seen and what can be done in California? And then Chuck, I'm going to bounce it back to you for if there's anything different in Texas. Craig,
Sure.
do you have anything to add?
And we're going to talk about a lot of these in more detail as we proceed through the presentation. But to sort of add on to what Chuck said in his review, one of the critical things is when you're reviewing those loan documents, when Chuck was talking about prior to initiating a foreclosure and things, one of the things you really need to look carefully at is to whether there are holes or weak spots or errors or things like that in your loan documentation. Because if there is, you may very well consider wanting to do a forbearance agreement with your borrower that gives you an opportunity to sort of clean up those errors. In essence, you're exchanging time for a fixing of the errors that may exist in your loan documents. It's one of the only chances you have to do that. And I think part of that forbearance agreement is you want a release from your borrower. You want a full-scale release from the borrower that if we're going to give you time in exchange, you're going to give me a full release. And if the borrower doesn't want to give you a release of all known and unknown claims, then you need to start talking with them, because that means there may be something out there that you want to flush out early on. Some of the other sort of options that are out there, a short sale by the borrower, which in itself has implications as far as whether you still have rights against a guarantor in some states, selling the note. There are a number of platforms out there for note sales that are fairly active over the last few years. Accepting a deed in lieu of foreclosure, which we can talk about later, and again has its own inherent difficulties. And then getting to the point where you just decide, okay, I'm going to go ahead and foreclose.
And most of the time, that's usually done at Comerica Bank. A lot of those decisions are made before I really get involved. It's really at the point of, okay, we're going to foreclose, that I get involved and start looking at everything from the environmental and the condition of the property and the back taxes or any of that stuff to decide, is this really a property that we want to own? And really, that's what the pre-foreclosure checklist. Every lender should have some form of a checklist for things that need to be looked at. Counsel should be guiding them through some of this to help decide, is this really a property that we want to own? We'll talk a little bit more about each one of these things as we go through this, but one of the things that you need to have to know whether you want to own a property, because it's different to do a loan on it than to want to own it. Access to the property is very important. Knowing whether you have seriously delinquent property taxes. We actually foreclosed on a property in Northern California where there was over $1 million in defaulted taxes, and the person that outbid us did not know that. So you really got to know the property as the lender and potential most likely owner. You've got to know a lot about the background, and that's what this pre-foreclosure checklist is about. Most of it's about title priority. Chuck, do you want to talk about that a little bit, and what to look into on a pre-foreclosure title report, and then Craig, I'm going to ask you what they call that. There's a different term for that in California, but Chuck, do you want to take that away on title?
Yes, sure. And just to step back a little bit, on your decision tree, when you're looking at your resolution alternatives, under a hypothetical, you have a Texas loan and you have underground gas tanks there. So as part of your decision tree is, I don't know if I want to be in the chain of title. I don't know if I want to foreclose on this property. I don't want to know if I have all the environmental cleanup obligations that might come if I take title to this property. So your resolution alternatives, and of course it depends on your appetite for risk. You're really looking for other alternatives other than foreclosures first in most cases. But clicking over on this pre-foreclosure checklist that we have on the next slide. First thing you always do is order a title report, in Texas anyway, because that tells you the lien priority and what else is out there. You usually get a tax certificate also, which tells you if the property is current on taxes. In Texas, any liens that were filed subsequent to your deed of trust lien are inferior liens. So if you foreclose, you terminate those liens, except for property taxes, which are certain real estate taxes that are assessed against that property by any taxing authority in Texas, and federal taxes, the IRS taxes, which can be terminated if you jump through certain hoops. So first thing to do, order your title report before you do anything moving forward in foreclosure. See where you stand, see if there's other liens that you have to deal with. One particular minefield that you will see in the title report when it pops up, and I've seen a couple loan officers get fired because of this. In Texas, there's what we have are called third-party tax liens. What these are is a private lender can pay real estate tax assessments on a piece of property and then step into the shoes of the government taxing authority as far as priority. When these liens and loans are taken out by your borrower, you as the lender are not notified. And I had one case, it's one where the officer got fired, where for 10 years, the borrower had been taking out third-party tax liens, paying off taxes without the bank knowing this, and essentially eating up the equity in the property because every single one of those loans and liens primed our bank. And really, the only way to learn about this is to order a title report. If that happens, then your decision tree changes dramatically. So you can get a tax certificate. It says taxes are current, but until you get a title report, you don't know who's paying those taxes and whether somebody jumped out in front of you.
To say that another way, the municipality, the county, and the ISD, the school districts, may be getting paid as part of that third-party lien. So it doesn't show on the county, yet you've got a third-party lien out there that you've got to deal with, and therefore, as borrowers get in financial stress, those type of loans are appealing, and they are superior to our liens, to a lender first deed of trust. So it's definitely something to look out for. Go ahead, Joe.
The crazy part is the bank doesn't get notice on that. You have no idea what's going on. The other particular very critical area, Keith, you touched upon earlier, is getting access to the property, because if you're thinking about foreclosing, you want to get your appraiser out there, and you cannot go on the property if you're, quote, breaching the peace. And most people are armed in Texas, so you don't want to breach the peace anyway. But if you circle back to our hypothetical here, you want to do your phase one. You want access to the property. You want to do some non-destructive testing, and you might want to do a phase two. You need some cooperation from the borrower to make that happen, because you cannot just go onto their property and start drilling core samples. If the borrower, now typically your deed of trust gives you the right to do that, it doesn't matter. You need to have cooperation. So, and we're going to touch upon this later, but sometimes you actually have to go to court to get a court order to gain access to the property. And depending on your borrower, you might want to bring a sheriff out there with you when you're going on the property to do your appraisal environmental testing.
Hey, Keith, there's one other critical.
Go ahead, Craig.
There's one other critical issue that ties back to the hypothetical here. And that's that this was a pool of loans that the pandemic bank acquires. One of the things you have to do when you get that pool of loans and you're getting ready to think about foreclosing, you need to make sure that all of the assignment documents from the old bank to the pandemic bank have all been done. The assignments of the deed of trust have been recorded, the allonges, all of the documentation necessary to assign those loans, because in many states in the country, you cannot initiate a foreclosure without all of the assignment documentation having been done and the assignments of the deeds of trust or mortgages having been recorded. And if you commence a lawsuit prior to having all that done, that's grounds for dismissal of the lawsuit immediately.
Yeah, Craig, I would put that under the doc review section of engaging counsel to make sure that's gone over. And it's really, that's something a special assets officer would start, truly at the very beginning of the consideration of the foreclosure process. But no doubt critical. You don't want to go foreclose and then find out you didn't have the rights to do the deed of trust. that
happens. You'd be shocked how often that happens.
Yeah, and I'm sure it's very costly to then overturn a foreclosure that was a non-legal foreclosure. Hey, what do they call in California? What do you call that the trustee sale guarantee? To explain what that is in California for California foreclosures.
Well, in general, once you've commenced a non-judicial foreclosure trust or sale, and we'll talk about what that is in a minute, but once you commence one, the foreclosure trustee usually reaches out to a title company and they prepare a trustee sale guarantee, which essentially says, here are the liens recorded against the property. And if you give notice to all of these different people, plus any other people that have requested notice and potentially guarantors and things as well, then you've done everything you're supposed to. And if you do all that, your foreclosure sale will have been deemed to have been conducted in a proper manner as far as the notice requirements of a sale go. But it's very, very helpful in getting, I mean, you find out right away after you've recorded your notice of default what the state of title is. Sometimes we will order, prior to the initiation of the foreclosure process, what's called a PERT report. Not all title companies will issue them, but the PERT report is a very inexpensive way to also verify the state of title and liens against the property prior to commencing a foreclosure sale.
Okay, and you mentioned that the TSGs are typically for non-judicial foreclosures. Craig, can you talk about, for California, the differences in when one might pursue a judicial foreclosure, which just in summary takes a lot longer? Base summaries on a judicial is going to take longer in court in pretty much every state. Certain states only have judicial. California and Texas both have non-judicial, which is like a posting foreclosure. But touch upon those differences in the timing, California-wise, on those two types.
A non-judicial foreclosure sale in California goes very quickly. You literally record a notice of default, you wait 90 days, you record a notice of trustee sale, and 21 days later, you can go to sale. The entire process can take 120 days. It doesn't involve, as the name implies, it doesn't involve the court system at all, and it is very inexpensive. You're paying a trustee's fees, which are statutorily defined, but you can generally negotiate those down, and you're paying a lawyer sometimes to review the documentation, and that's about it. Now, the downside with, and one other thing with a non-judicial foreclosure sale, if you go that route, there is no redemption period. It's over. If you, the downside.
So the day of the trustee sale, the day of the foreclosure, you can get title. You can get title recorded.
You're done. You get title insurance. Yep. You can own the property then, and you record a trustee's deed upon sale, and you then own the property. The downside of it is you have waived any right to seek a deficiency against your borrower. And so you're trading speed for not being able to pursue a deficiency against your borrower. A judicial foreclosure, on the other hand, is regular litigation. You file a lawsuit, you wait for an answer, you go through the discovery process, you file a motion for summary judgment if you have all of the evidence necessary to do so. Otherwise, you go to trial. And at that point, once you get what's called a judicial foreclosure judgment and order of sale that basically says, here are the amounts owed to the lender, and the lender can proceed with the foreclosure process. Once you get that judgment, then you hand that off to a sheriff or a marshal who conducts a foreclosure sale. And within 90 days thereafter, you have to file your motion for your deficiency judgment. So the judicial foreclosure process can take well over a year, and with the courts even more backlogged now than they are before, it'll probably take much longer than a year. And you'll have to incur all of those expenses. But the benefit is you are, again, the ability to pursue a deficiency judgment against your borrower. There is also, with a judicial foreclosure, a 1-year right of redemption, and we'll talk about redemption issues later on, but during that 1-year right of redemption, it's very, very difficult to sell the property.
Okay.
And I should add that both of those foreclosure sale processes in California can be run simultaneously.
And one thing, when you hear about a sale, a foreclosure at the courthouse steps, that's usually going to be a non-judicial posted foreclosure. When you hear about a sheriff sale in California, it's going to be a judicial, because the sheriff is usually who handles those. But not so much in Texas. Chuck, you want to talk about those differences real quick? Because I think we're falling behind on timing. But if you'd explain, I think in Texas you can pursue both. You can pursue a deficiency through a non-judicial. Can you explain that?
Sure. Yeah, Texas is quite a bit different. Texas, your foreclosure laws are a lot more creditor friendly. So a non-judicial foreclosure is relatively simple. You give 21 days notice and you post it 21 days before the foreclosure date, and you conduct the sale on the first Tuesday of the following month, as long as you got that notice period.
And where is that posted? Where do you post that?
It's posted typically at the county courthouse where the foreclosure sale will take place. And there's a board where it's just posted. And you give notice to everybody and all the obligors and all that. If there's federal tax liens, you give 25 days prior notice. But it's essentially, you have your date on the calendar 3 weeks before the first Tuesday, you go forward with the sale. And actually going forward with the sale is very flexible, because you can always pass on the foreclosure sale without any penalty and repost for the following month. So the bank or the creditor appoints a substitute trustee to conduct the sale. Substitute trustee conducts the sale any way they want to. They can demand cash on the courthouse steps. They can conduct it like auctions you see on TV. Really, it's a lot of flexibility. With judicial foreclosure sales involving the court system in Texas, you use that rarely, because the process can take a considerable amount of time, because you do have the court process involved. And so we typically only see it when specific circumstances, primarily being when you have you want to get a receiver involved to actually foreclose on the property, because you do not want to be in the chain of title, which would happen in an environmental situation. But I've got clients who will go for judicial foreclosure sale if the borrower is threatening lender liability claims against the bank. They're saying, you know what, I'm going to have a judge tell me I can go forward with my foreclosure sale, and so we can address with these claims the borrower's making. I've got another bank which makes a lot of faith-based loans, and they really don't like to foreclose on churches. They don't like publicity. Same with daycare centers, charities. Keith, we have one with the charity, and you don't want to be on the front page of the paper saying ABC Bank closed on this charity that helps widows and orphans. So we'll go through the court system, we'll get a receiver, we'll let the receiver handle that, take all the heat and do all of that. And that has to be done through a judicial foreclosure.
We call a lot of that reputational risk. You've got operational or premises risk, and then you've got reputational risk. And Comerica is very careful about that. I'm sure it gets back to the risk tolerance factors. Let's see, we've kind of covered a lot of this. Mechanics of judicial.
Keith, let me interject real quick.
Yeah.
You do not waive the deficiency in Texas when you conduct a non-judicial foreclosure. If there's deficiency on the loan, you can always proceed with the court systems like a regular collection lawsuit for the deficiency that's left on the loan, subject to the grantor's right to contest the bid, but we'll address that later.
Okay, moving into this section of judicial foreclosures in Texas, specifically receiverships. I know you can't just force a receivership, but you can go to court, and there may be, and I would say the most likely reason for a receivership is an environmental issue where the bank does not want to step into chain of title. We've had short-term receiver. I shouldn't say, there are cases where you want a receiver just to button up a building, maybe it's under construction, and the general contractor and the borrower have gone belly up, and you want to protect that asset. That might be another reason to quickly get a receivership. Most of the time it's to clean up or take some action environmentally, sometimes just to allow access, because the borrower is not letting you do that, and you can put a receiver in place or get a court order to get access. But receiverships, let's talk about the differences in California and Texas. How long does it take, and what happens to put a receiver in place, and who exactly is a receiver? You want to address that first, Craig, in California?
Sure. In California, there's two types of receivers in nationwide, and in California we have, like all the other states, we have two types of receivers. We have a rents, issues, and profits receiver, which is essentially a receiver that is appointed over the property to collect the rental income and safeguard the rental income and operate the property pending the completion of a foreclosure sale. Those are far and away the most common form of receiverships in California. They are fairly routinely granted by the judges. They're familiar with them. They understand the concepts. And most judges, if you're not being paid as a result of a monetary default, most judges do not have a problem with having a receiver appointed to protect the rents that are being paid by the borrower or by the tenants and safeguarded for the benefit of the lender. An equity receiver is a whole nother can of worms, and essentially you're replacing the management of a borrower. those are more difficult to have obtained by a court. They don't really like to do those as often, and they tend to be more prolific in the federal court system with federal equity receivers in conjunctions with Ponzi schemes and things like that. But the process of getting a receiver in California, and I'm focused on rents, issues, and profits, which also dovetails into if you needed to get one for environmental issues, is you can file a noticed motion, which is on 20-some days notice, and you basically make a showing to the judge that you have a deed of trust against the property, and you need to be able to safeguard your interest in the collateral, or else, and that generally works reasonably well. Or you can go in on an emergency basis, and the emergency basis is when you say to a judge, you give a borrower 24 hours notice, and you have to give it by 10 o'clock the day before you're going into court. You go running into court and you say, Judge, this borrower is really stealing me blind. And so I need to have a receiver appointed immediately to safeguard my interest in the rental income. Right now in California, there really aren't any great emergency issue or excuses to go in because all the courts are so largely shut down. And a noticed motion would take forever to get heard right now because of the shutdown in the court system. But from a practical standpoint, in normal times, getting a rents, issues, and profits receiver appointed is a fairly easy process.
How about Texas, Chuck? Is it fairly simple? Sometimes depends on the borrower, depends on the situation. What do you think?
It's a simple process in Texas, although there are some risk involved. And you know, currently during the pandemic, our court systems are open, although most hearings are being conducted over Zoom or Skype or online. But we are getting some progress. But some of the issues with the receiver is, first of all, do you as the lender have the right to seek a receiver? And so you have to circle back to your loan documents and see if you have that right. If not, there are statutes in Texas, and you have to qualify under the statute. The biggest problem with the receiver I have seen is the loss of control over your destiny once you have the receiver in place, because the typical receivership order that is approved by the court, the receiver runs the company. The receiver handles any disposition of the collateral. The receiver goes out and collects ARs. The receiver is essentially operating that company in most instances. And so you need to have a good receiver or a friendly receiver, somebody you like. Although you can ask the judge to appoint a receiver, and our practice has been, we know a lot of good people who have a long history of receiverships. They're trustworthy. The judge can appoint anybody they want. So you might have a judge say, well, I've got this worthless brother-in-law who doesn't have anything else to do. I'm gonna make him the receiver over this property, and my niece is gonna have her college tuition paid for. Because the receiver gets paid off the top, and that usually comes out of dispositions of collateral, collection of ARs. It's money that the bank would otherwise be receiving. So we have had horror stories where we get a bad receiver who is just feasting on this with their buddy, the judge, and there's nothing we can do about it. We've gone in several times to have a receiver removed for incompetence or just charging us too much. So the receivership's not the be-all, end-all. The good side of it.
It certainly creates an expense. It can create problems, but it can also, if set up right and the right receiver is appointed, it can certainly aid in staying out of the shade of title and getting a property liquidated, something that we wouldn't want to put in our name.
Hey, absolutely. Two minor points I'd like to interject about a receiver. The first point is, the golden rule of California is he who has the receiver appointed pays the receiver's bills if there's not enough income being generated by the property. If your property is only generating, $5,000 a month in rents or $10,000 a month in rents, and at the end of the day, your receiver presents you a bill that is way more, and asks the court to approve his invoice for way more than you're collecting, the bank's going to get stuck writing a check for that. So when you're deciding to get a receiver appointed, you need to do the economic analysis of, is there enough revenue being generated to justify having a receiver appointed? Otherwise, you're going to be, we as lawyers, when they go through this process, we're going to have a very unhappy client at the end of the day if they've got to write a big check to make the receivership go away. The second point that people tend to overlook is that, and I say this from a litigation standpoint, keep in mind that everything you say as the banker to the receiver is discoverable. That means if you are saying, that son of a gun borrower, no good, lousy, lazy, blah, blah, blah. If somebody asks, if the borrower is taking depositions in the case and deposes the receiver and is asking, what about the communications you've had with the lender on this deal? All of those discussions are discoverable. They are not protected by, in California at least, by the attorney-client privilege, work product privileges, any other privileges. It's fair game for a borrower's lawyer. And we've seen cases where lenders have gotten themselves into trouble by talking too freely to a receiver. So just sort of a word to the wise, practical advice on if you do get a receiver appointed, be careful what you say, be careful what you write, be careful what you send in emails.
Essentially, receivers working for the court and for all creditors, not just you as the lender. However, a good receiver should know that they're working for us. So
with a wink Kyle, exactly.
Craig, one more thing. Can you talk a little bit about the one action rule? Because again, it goes back to some of the early decisions that are made. But in California, it's a huge factor in whether you're going to foreclose or not. Go ahead.
Sure. The one action rule, and I call it California's infamous one action rule because it has been the subject of hours and hours and hours of presentations and volumes of pleadings and treatises and things on it. And it's the mechanics of all of the details and the implications of the one action rule we could spend hours talking about. But in distilling it down for purposes of today's discussion, what I want you to go away from with this is if you have a loan in California that is secured by real property, you need to do two things. One, you need to realize I got to figure out a way to dispose of my real property collateral through a foreclosure process before I can really do anything else. And there are a couple of minor exceptions to that, but before I can do anything else. And two, I better consult with foreclosure counsel or counsel that understands the one action rule because the implications are tremendous. If you violate California's one action rule, the sanction for doing so can be the waiver of your real property collateral. And let me give you the quintessential example of how that comes about. If let's just say that you have a deal where the borrower owes you've got collateral worth $1 million, and you discover that your borrower has a checking account with the bank that is unpledged. It's not part of your collateral package at all. It's just a separate operating checking account that has $3,000 in it. There was a case years ago where a bank set off on that $3,000 checking account, applied it to the debt, and when they went to foreclose, the borrower's counsel said, no, you offset an unpledged checking account. You have violated California's one action rule because you didn't deal with the real property collateral first, and you have waived your real property collateral. So in essence, for taking $3,000, they gave up $1 million piece of property. So people call it a draconian rule. It probably is when it's applied in those types of circumstances, but it is something that you have to be keenly aware of whenever you have real property collateral. And there are other states that have similar rules. I think Nevada has a similar one action rule. I'm not sure. I think Arizona may as well. There are other states, but the first thing to recognize is the minute you see real property collateral in California, your antenna should go up that, oops, I need to figure out exactly how I have to navigate through this process because it does often change the dynamics of how you're going to proceed.
Excellent. Okay, moving back to the slides, trying to keep this moving. What types of issues, environmental issues, may keep the bank from foreclosing? Every lender is going to have to have their own risk tolerance. I mean, we certainly have taken property and used an LLC to take title when we knew we had some minor amount of cleanup to be done. And I mean, things like, and usually we'll try to work to make it happen before the foreclosure, but we still might, if there's some level of concern, we still might put it in an LLC to try to curtail some of that liability. It's going to have to be every lender making their own decisions. We have an internal group for helping make those decisions. We certainly aren't opposed to going to environmental counsel, and Chuck and Craig are not specific environmental counsel. They do have other attorneys at their firm that can help with those type of details. So that's all got to be considered, and it's part of dovetails back into the receivership. Is it worth getting a receiver when you have those type of concerns? Getting back to this slide on delinquent property taxes, which Chuck detailed pretty well. You talked about third-party taxes. I think this has already been covered. potential contamination. Chuck, you want to bring up again, you mentioned gas stations. What types of things come up into play with gas stations specifically?
Well, it's you have an underground storage tank, and so you have almost by definition some degree of contamination. You don't know if there's been leakage or spills, but you're put on notice that you need to do a phase 1 and probably a phase 2. This kind of gets into your decision tree on what are the environmental statutes. Now that you have the federal statutes, but each state also has their state-specific environmental statutes. We have offices in Nevada and Las Vegas, and we do a lot of work in New Mexico and Oklahoma, and the state statutes differ dramatically. So Keith, your suggestion is talk to your environmental expert, because that's what you need. There is certainly an area of expertise that is involved in any environmental issue.
And what about access here again? How long does it take in Texas if our borrower just doesn't return phone calls and we need to get access to property?
Right, that's what I was moving to. And access, if they will not cooperate and you cannot get in there to do your environmental inspection and testing without breaching the peace, you have to file a lawsuit. So that's filing a lawsuit, getting the defendant served, giving them their 20 days plus to answer the lawsuit, and then file a motion for access, which you have to have set in front of the judge. You have a hearing after giving notice, and you have to show the judge your loan documents and your deed of trust that says, I'm supposed to get access, I need to do this, X, Y, Z. The judge then orders access, gives you a specific day to do it, bring the sheriff with you if the borrower's not cooperating. All this can take several months depending on the court system. And particularly right now with the pandemic, the court systems are not operating efficiently. They're not hearing as much. So this thing can drag out. But I would caution anybody, not just send your guy out there to do your environmental inspection without the borrower cooperating, or you can catch a counterclaim for breaching the peace.
Hey, Keith, in California, we have a little bit different approach to it. As long as we've made repeated requests over a reasonable period of time to a borrower for access, and if they just thumb their nose at us, I can go in on literally 24 hours notice and get access to that property. We have our receivership statutes specifically provide that we can have a receiver appointed for the limited purpose of doing an environmental inspection as necessary to protect and preserve the collateral. And so
does that mean cutting locks also, Craig? Does that mean if you need to go inside?
If the receiver has to, if the receiver needs to get in there, the receiver has the ability to do that. We have gone in literally on emergency notice and said, we're ready to foreclose. We need access immediately. They won't give it to us. And we've had judges sign off on a receivership order, and the receiver goes out there the next day and takes care of getting the, doing the environmental and doing the things that are necessary. And if it takes longer than a few days, they do their thing and they get it done. But it's really stupid when you show up before the judge and he says, why are you here? And it's because, well, they won't let us come on and do an environmental inspection. And then they look at the borrower and they say, why won't you let them do that? They're entitled to do it. They're authorized to do it under the loan documents. What kind of game are you playing here? And it doesn't take a judge very long usually to immediately appoint a limited purpose receiver to deal with the environmental inspection and things like that.
And following up, Craig, we can do a similar thing with receiverships in Texas, but the way they do it here is your receivership order. When the receiver's appointed, one of the bullet points on their powers is to have access to everything and for inspection, including environmental everything. So going in with the appointment of the receiver does have those rights and can do whatever they want to at that point. So then we don't have to get a motion for access.
How about, hey guys, what about if there's a bankruptcy filed? I mean, in my experience, a bankruptcy is going to stop us from progressing on a foreclosure, and typically it will slow us down and probably stop us on pursuing environmental due diligence, but maybe legally you can do that. Tell me about that. If there's a bankruptcy filed and the borrower is willing to allow access, there's no reason you can't continue with environmental due diligence. Is that correct in both states? Craig, you want to go first?
Yeah, if the borrower and or in a Chapter 7 case, the Chapter 7 trustee, maybe in a more typical Chapter 7 environment, you would have the trustee that would have to give you that approval as well. As long as they're okay with it, I don't think there's any problem with you going ahead and doing it and getting your inspection done. I would think if they are not going to give you access, then I think you have grounds to go in and have the automatic stay modified for cause so that you can have access to the property to do those types of environmental inspections that you're talking about. I would find it to be very difficult for a bankruptcy judge to deny a limited modification of the automatic stay motions that we are simply trying to get access to be able to do something like that. That doesn't seem to be, you know, a big issue to have a judge say, yeah, you should be entitled to do that. And I think a lot of bankruptcy judges would be rather livid if the borrower just didn't consent to it, or a Chapter 7 trustee just didn't consent to it.
Okay. Let's bring up the scenario of hazardous waste is found. Say it's very minor, but there's some type of, there's barrels with some known contaminants and they have to be hauled away. Craig, in California, is this something you think a receiver should be appointed for? Do you think you go ahead and let the borrower do that if he's willing to do it, if the bank's willing to pay for it? What is your opinion on how to deal with minor levels of hazardous waste to be removed?
If we're talking within the bankruptcy context, then the debtor or the Chapter 7 trustee is going to have to deal with it. If we're talking outside
let's take away the bankruptcy. Sorry, outside of bankruptcy. Sorry.
Outside of the bankruptcy context, my strong recommendation would be to not have the bank get involved in any aspect of it at all. That'd be additional reasons to go in and get a receiver appointed, let the receiver deal with it. The receiver, in dealing with those types of issues, who again is an agent of the court, that he's an officer of the court, he reports to the judge. The receiver is going to go in before doing any of those types of things and get the court's blessing on his plan before he does anything, he or she does anything with respect to environmental issues. And that gives the lender, you stay out of the line of fire. You're not going to get sued for anything that goes on. And it's difficult to sue a receiver. You actually have to get court permission in California to bring an action against a receiver. And if the judge has already blessed the action that the receiver wants to take, getting a judge to say, yeah, now you can sue him is not going to work out so well. So I know that there are some instances where banks go ahead and they do sort of advance money to do things like that. My personal preference would be to let the receiver do it and stay out of the line of fire.
And Keith, this is Chuck, just to digress momentarily back to our bankruptcy scenario. When you have a Chapter 7 and a bankruptcy trustee is appointed, if you do have collateral that has environmental issues, well, that Chapter 7 trustee, that trustee can be in charge of disposing of that collateral. The bank doesn't have to do it. The bank doesn't have to foreclose. The bank doesn't have to do anything. The Chapter 7 trustee can sell all of the assets because it's a liquidation. So we tend to like that when we see environmental issues and then they file bankruptcy. Let the Chapter 7 trustee deal with it.
You know, Keith, it was kind of funny. We had a deal.
The negativity on that is only what does it cost? What does it cost to have that trustee? Because then we're really out of control for what that might cost. And a lot of bankruptcy trustees will have their own counsel, their own CPAs, and you know, there's definitely a charge to that. But I hear you. In some cases, there's a huge benefit to that.
It's analogous to a receiver. It's analogous to a receiver. Same cost involved.
Yep.
We had a situation years ago where we wanted to get to the point where the Chapter 7 trustee or a Chapter 7 trustee was going to have to deal with it. So we filed an involuntary petition to force the debtor into bankruptcy, which solved all those problems. Exactly what Chuck was saying. We had a trustee deal with all the issues. The lender never had to deal with it, but we had enough creditors that we met the requirements to have an involuntary petition filed, and it worked out exceptionally well.
That's brilliant. That's great.
Okay, so a few more wrinkles. You find let's call it significant contamination, potential vapor issues. You know, this is through what, maybe 2 phase 2s. You may have done 2 or 3 reports. I can tell you this is the point where, you know, our internal environmental risk management is definitely going to be involved. We're probably going to have specific environmental counsel. This kind of overrides if you have, you know, issues that create human health concerns that may need some type of regulatory reporting. We're going to always run that by environmental counsel, because you're definitely probably walking away from a foreclosure or any other collection action on that property and may need to do notifications. I'm never going to be the one to make that decision. We're going to bring in specific counsel and probably a peer review on the environmental to make those decisions. we probably used and mentioned special purpose entity. You know, I think that's more for really low levels of concern, not for the higher levels of concern. So I'm not going to have you guys talk on that. Let's talk about reinstatement of a loan. How soon in California, if you've got a posted notice of default and trustee sale notice out, when can somebody reinstate a loan? How close to the foreclosure can a default be corrected and the loan be reinstated? Craig, can you talk about that a little bit?
Sure. In California, assuming that the default is one that is susceptible of being cured, for example, they've missed monthly payments, that type of thing, a borrower has up until 5 business days prior to the foreclosure sale to reinstate the loan. And this has led to all kinds of games playing in the state of California. It's almost as if borrowers sometimes do it as a cost of doing business analysis, is that they'll let their loan go into monetary default. They will let it go on for months while the foreclosure process goes. They don't pay anybody during that period of time. And then 5 business days prior to the sale, they run into the foreclosure trustee, they get the payoff, they pay the money, and they start the whole process. And 2 weeks later, they're right back in default, and the whole process goes on and on and on. And I've had clients complaining, saying, isn't there anything we can do about this when they're just making these failure to make monthly payment defaults? And my response has been, yeah, you can vote new legislatures in the state of California that will change the law, because that's what the law is. And there's not a whole lot you can do about it if somebody really wants to play that game long enough. And many.
What if you've got a fully matured loan? If your loan is fully matured, that's not the case, right? They have to.
Yeah, that's not a default that is susceptible of being cured, other than paying you off in full. So when it's a maturity default, it's a little bit different story. But just a failure to make a monthly payment that you start a foreclosure process on, it can just go on and on and on. And there's as long as they want to play the game and are willing to pay, because when they reinstate the loan on those types of situations, they have to make up all the missed payments. They have to pay your attorney's fees. They have to pay all the other advances that you've made during that period of time. They have to pay the trustees' fees. They basically have to make you whole. But if they're willing to play that game, there's not a whole lot you can do about it.
And then it all comes back in 6-8 months. You're back where you started. How about Texas, Chuck? Is that similar timeline in Texas, or
no?
Didn't work.
No, Texas does not have the reinstatement statute. So as long as you have accelerated the remaining indebtedness due on the loan, pursuant to the loan documents, the only way to reinstate it would be to pay off the loan, the completely accelerated amount. They can make payments, and you can say, thank you very much, send your reservation of rights language. I'm still proceeding with collecting the remaining balance, and I'm still going to foreclose. And Keith, if you indulge me for 2 seconds on special purpose entities that we went over.
Oh, yeah.
That does come into play quite a bit when we have property with environmental contamination. And I'll try to be brief. I've had lenders who don't want a receiver, can't put them into bankruptcy. The property has environmental issues. They do not want to foreclose. They do not want to be in the chain of title. So what they have done is created essentially a shell company that will acquire the loan and all the collateral through assignments, through an arm's length purchase, so to speak. And this special purpose entity that's created then forecloses on the property and then sells it. This company's in the chain of title. So if there's environmental issues, environmental problems that as a owner of the property they get hit with, it's a company with no assets. You run other risk of maybe somebody trying to pierce the corporate veil and things of that nature. But I have had clients do that with considerable success of disposing of property and staying out of the chain of title.
Excellent. I would say that Comerica is still very careful on use of SPEs. We have used them, but we're still very careful with when we use them and what type of contamination. But go ahead.
The practical reality on a lot of these loans that have contamination issues, there's a big market out there for people that will actually buy the notes. And so quite often your best source of a resolution is to sell a note to one of these entities that has no problem at all acquiring these types of loans and has no problem foreclosing on them and has no problem owning the real estate at the end of the day.
All true. And I've been surprised at what people have paid in some cases on note sales, even versus a property sale. It's been baffling based on loan balances. Some groups won't even value a property. They've looked at just a loan balance and decided a factor that they would pay, and it's been amazing knowing that there's problems with the property. Okay, can we move on a little bit here, because I think we got about 5 minutes left. Foreclosure bid pricing. Most states, you have to bid either your maximum debt or some version of value. You can decide what you're bidding, whether you want to start with a lower bid and bid in increments to bid up to, but it has to end with something that is of some determination of the value of the property. You can book it in, carry it on your books at a lower value, but you have to bid it based on some version of value. You can allow for your costs and holding costs and delinquent taxes. You can allow for that, but it still has to be based upon a fair value that you're utilizing, or the full debt. I can tell you, not all states, Florida, Maryland, there are a few states that start at $100, and if nobody else bids, you can acquire a foreclosure for $100. And banks like that, because you pay the transfer taxes or what they call documentation stamps based on that bid price. Craig, do you have anything to add to that for California? Anything specific?
Yeah,
of bid pricing?
In California, we would rarely advise a client to make a full credit bid. And the classic example is when you have a receiver appointed over a property. If you're owed $1 million and the receiver is holding $200,000, if you make a full credit bid of $1 million, that money that's being held by the receiver goes back to the borrower, which is not something you want to see happen. So in most of those instances, you want to at least underbid by at least the amount of the money that the receiver is holding. And like in our example here, if you're owed $1 million, the receiver is holding $200,000, you might only want to bid $600,000-$700,000, so you've left yourself a cushion so that you can go get the money that the receiver is holding, because that's a separate part of your collateral that you can get back to be applied to the debt. And that's real money as opposed to just some credit bid that you're making. But we very, very rarely, unless there's going to be competitive bidding and the client is happy to make a full credit bid and then take whatever happens, and walk away from it at that point, we generally don't have a problem with that.
The borrower wouldn't get that money back if there was other sub debt. Say you've got a second and a third recorded to title, they would get money before the borrower. Is that correct? Correct?
Yes, they would. They would. I mean, the money, but in this instance, since it's our collateral, I have seen cases where the judge did not award the money to the junior lien holder because it was our collateral, and they ended up giving it back to the borrower. So that becomes a little bit of a crapshoot, but we want to make sure we can get our hands on that money.
Yeah, and one thing, you don't want to bid too low of a price. Somebody can take it away for a lot less, but you can also have a lawsuit. A borrower can sue based on a falsely creating a deficiency because we're bidding too low. Most deficiencies are set by what that public bid number is. And I can tell you, I've been involved in a lawsuit where they felt we bid too low, and we of course won, but because we had definitive calculation to how we backed into that from a fair value where the bidding started. But you got to be careful with that. There's certainly rules to pay attention to for foreclosure sale bids. One thing you can also...
Keith, I was touching upon that. By statute in Texas, a borrower can sue you if they believe the foreclosure bid price was too low. Now, the only thing they can achieve is to have their deficiency reduced by the amount the judge ruled should have been the fair market value bid price plus holding cost. They don't get attorney's fees. They don't get any affirmative relief from the bank. They just get their deficiency decreased.
Right.
Yeah,
Okay,
in California, there are statutory protections built in determining the amount of a deficiency, if it's even a judicial foreclosure where there's a deficiency available, to protect against exactly that kind of thing happening.
Okay. Greg, walk us through just a traditional non-judicial foreclosure courthouse step sale in California. I mean, you guys, by the way, you can YouTube this and watch them happen. Not really a sheriff sale. That's a difference. But what happens on a courthouse steps when a trustee brings a property to sale? Just real quick.
It's really the classic American version of capitalism. There's live bidding. A private foreclosure trustee shows up on the steps. They announce that the sale is going to take place. They usually announce that the initial bid by the secured creditor is X amount of dollars. They ask, are there any other bids? And then the bidding process begins. And it can go up in increments of $5, $10, $100,000, whatever people are bidding, they can do so. And I have actually stood out in the courthouse steps at Pomona one day in 110-degree weather for 5 hours watching a foreclosure sale go. Our client got out of the bidding when it had made its full credit bid, but there was still third-party bidders that wanted to continue driving the price of the property up. And at one point, the increments were like $1,000, and it was crazy. But we stood there for 5 hours watching people go through that process. And at the end of the day, the final bid comes in, and the judge or the foreclosure trustee says, sales concluded, and the successful bidder is the ABC entity, and that's what happens. The vast majority of the foreclosure sales, no one shows up, and the full credit or the credit bid made by the foreclosing creditor is the number that is where the property sells at.
Yep. Okay, we got to move on. Chilling the bid, Chuck. What's chilling the bid? What makes you concerned about chilling other bidders?
Well, that's a lender liability. It's in Texas, typically myself or other attorneys at my office are appointed as substitute trustee, and we actually conduct the sale. And we have to be very neutral and conduct the sale where we have the highest possible bid price for the property. So that means you cannot favor any other bidder one over the other. Everybody gets the same information. You have to conduct the sale on the courthouse steps. You have to announce yourself. You have to give every opportunity in the world for other people to bid to drive up the price. Now, with the current pandemic we have an issue where in some of the larger counties like Dallas and Houston, there'll be hundreds of people at the courthouse where they are conducting the sale. Houston, it's at a convention center, and they're not going to show up right now. There's no 6 feet apart. So if you were to conduct a foreclosure sale right now in one of the urban counties, I could see a borrower saying, because of the pandemic, there were bidders who did not show up, and you should not have conducted the sale. We got a lower bid price. You chilled the bid. And they sue the trustee, and they sue the bank, and they sue everybody else. So the trustee who controls this has to be very, very careful how it's conducted, what they say, how they say it, and just to have every opportunity in the world to achieve the highest price at the foreclosure sale.
And Chuck, at least in California, I assume similar here, there's no case law that's going to describe how you deal with those arguments that are made as a result of the pandemic. Because the last time we had a pandemic was 100-some years ago. I wasn't around for it. And there's no case law from that last pandemic as to how foreclosure sales got impacted. And no one really knows exactly how a court is going to deal with those claims when it's made that there was a bid chilling process because nobody could show up for the sale. I know a lot of the foreclosure trustees in California are not too keen on conducting foreclosure sales right now. I've been able to get several of them done over the last month, but it takes some pushing and some pulling to get all that done, but that no one knows how a court is going to respond to those arguments right now.
Absolutely. And Keith, just to touch on your last bullet point on this slide, TRO, that's, and I'm sure it's the same in California, that's when the borrower, the grantor, wants to stop a foreclosure sale. So they file a application for a temporary restraining order. Most judges will allow at least one of those to be granted to pass on the foreclosure sale and make you repost again for the following posting period, which would be the next month in Texas. But we've had cases where
that happens the morning of or the afternoon just before a foreclosure or something just before it, right? So that it's really hard to know exactly when that might be filed, correct?
Right, exactly. And they're supposed to give you notice. In Texas, under most local rules of the courts, the other side's supposed to give you notice, call you up, do all those things. But I had one I conducted about 6 months ago where there's actually a hearing going on in front of the judge. And this is the 4th TRO they had filed to stop one. And we were conducting the sale while the judge was hearing everything. And we closed it before the judge ruled. He ruled in our favor, thankfully. But my client had enough and said, get it done. If we're not ordered to stop, go forward. So it is a stall tactic in Texas, analogous to the California rule on reinstatement of the loan, where they can make partial payments and delay the foreclosure inevitably.
Keith, one interesting trick of the trade in California is when somebody goes in for TRO or other types of injunctive relief, they have to tender the amounts that are not in dispute as a condition to getting that relief. And many judges don't like to see these things noticed, on an emergency basis, because it's a self-created emergency. They've known the foreclosure is going on for months after month after month. And if they are not disputing all of the amounts that are owed, if they're only disputing, say, a certain number or something like that, you can often get up and say to the judge, look, judge, we'll waive this figure or we'll adjust this figure, but they got to tender all the other amounts that are owed. And if they fail to do so, there's absolutely no basis for them. They can't meet the requirements for getting injunctive relief.
Excellent. Yeah, good to know on all that. From this slide, you guys Craig, explain what a deed in lieu is and when we might want to do a deed in lieu if title is correct and that kind of stuff. Can you talk about that for a California loan?
A deed in lieu of foreclosure is sort of another way of foreclosing where you negotiate a transition of the property back over to the lender. It really only works in instances where there are no junior liens against the property, because if you are the lender and you accept a deed in lieu of foreclosure, you are taking it subject to junior liens, not just senior liens. You're taking it subject to junior liens as well, because there's no process to wipe out those junior liens. Our experience in California over the last few years, and I did 5 years ago, I think I did 10 or 12 deed in lieu transactions, and I sort of timed them to see how long it actually took to do them. By the time you get done negotiating all the documentation for a deed in lieu transaction, including the resolution of any guarantor liability, to the extent that you're going to try to have the guarantor pay part of some of the money to be released off his guarantee, it takes way more than 120 days to get the deal done, and you could have foreclosed within that period of time. There are other issues, mainly title insurance. It is very difficult right now to get a title insurance company to give you a title insurance policy on a deed in lieu. They just don't like to do that right now. And so we don't see a lot of the transactions in California happening right now.
You know what, you see them in Michigan. We actually have done a few deed in lieus in Michigan because of the redemption periods that have to be waited. We will give up a little bit of let's call it value to take a deed in lieu as long as title is clear. And you can get, and it's kind of funny, in Michigan, you definitely can get, at least we've been successful 3 or 4 times in the last year on getting title insurance on a deed in lieu ownership. Okay, anything else on this slide that we want to touch upon? I'm trying to catch up. We are literally 8 minutes behind on when we're supposed to finish, so I'm going to jump ahead unless there's something else you guys want to bring up. Redemption rights, like I said, Michigan 6 months. Some properties in Michigan are 12 months. What is it in California on a judicial sale? Is it 12 months, Craig? Is it?
Yeah, there is none on a non-judicial foreclosure. There is no redemption period. On a judicial foreclosure in California, assuming you obtained a deficiency proceeding, there is a 1-year right of redemption. And an interesting fact about that is during that 1-year right of redemption, your borrower can continue to be in that property as long as they're paying you rent.
And it's a redemption for the borrower only, right? That's who can pay off the loan.
Yeah, essentially believe it or not, there is a market, because when you complete a judicial foreclosure in California, you get a certificate of sale. And while the property itself is difficult, it's almost unsaleable during that period of time, there are people that will buy these certificates of sale so that they're basically assigned to a third party that may, want to hold the property and own it that way. So there's a small market out there for that kind of stuff, but for the most part, you're kind of stuck for a year sitting there, letting your borrower live there or operate out of the facility. And as long as they're paying you rent, there's not a whole lot you can do while that redemption period, runs its course.
And Chuck, Texas, no redemption periods, right? For either.
There's no redemption periods except for federal tax liens, which would applies to all states. So let's say you foreclose, you give the IRS office the 25 days prior notice of foreclosure, you terminate that federal tax lien on the property. The IRS, the Treasury actually, has 120 days to exercise redemption rights. It essentially means paying off the property, which is rarely ever done, but it's out there. They have a 120-day redemption period. Keith, I think you went silent there.
Yeah, I've lost him as well.
Yep,
Well-
Keith is offline.
Okay. Well, I think, wasn't that the last slide?
Sure.
If not, it is now.
We've got quite a few questions though, so we might want to start fielding those and get to as many as we can before we run out of time. And I do want to let everybody know that what we don't get to, we will get answered, and we will follow up in an email to the people that attended this recording. So with that, Georgina, do you have your mic unmuted to start fielding some of the questions?
Yes, can you hear me?
Yes.
Okay, good. And first of all, I just wanted to give a big thanks to all the speakers, which I know Barbara will be doing too, but in particular, I wanted to thank Barbara. She knew Keith and these attorneys, and without her input and involvement, we wouldn't have had this wonderful webinar. So thank you, Barbara. I've got a few questions here, which mostly revolve around environmental and receivers and what can somebody do. So the first question is, what are your thoughts on using a receiver to get rid of investigation-derived wastes pre-foreclosure? Does the bank have input for choosing the disposal method when a receiver is in place, and who signs the manifest?
Well,
So just for Craig?
the short answer is the bank has input, but the receiver's making all the decisions. And so it's completely incumbent upon the receiver to determine what to do and how to do it.
Yeah, I totally agree. Again, the receiver works for the court, and the receiver is an officer and an agent of the court. And before the receiver is going to undertake the type of things you're describing, the receiver will engage counsel, and they will make an application before the judge seeking authority to do exactly what you're describing, the types of actions you're describing. And the judge will either approve it or they won't. And I assume as part of that, the receiver may have the authority to sign the manifest. That would be part of however the judge decided they wanted to handle that. But no receiver worth his salt is going to undertake those types of activities without getting approval from the judge.
Yeah, and you guys, I'm back. Sorry, I don't know what happened there with the audio. I had to retie back into VPN, but hey, this is where be careful what receiver gets selected. You've got to be extremely cautious and making sure you've got somebody qualified. Receivers are bonded. They're working for the court. You want them to make the right decisions, but if they make the wrong decisions and spend 3 times what it costs to do that, needed remediation, well, you get to pay for it. So be careful. But at the same time, it's a way of, still collecting on a property and getting it cleaned up.
And that receiver will engage extremely expensive environmental consultants and counsel for any decisions that's made. So you have to be aware of those expenses.
They're usually pretty cautious, yes.
Yeah. Yep.
Well, and
So
they
the
have
first
to
question-
be. They have to be because they're, the last thing that a receiver wants to do, because I represent receivers and things around the country as well. The last thing that a receiver wants to do is go before a judge with his head between his legs saying, hey, judge, I did all this, this, and this, and it blew up in my face. And I should have come to you and let you know ahead of time. In those instances, that judge will never appoint that receiver to do any additional work anywhere from now on. So they're very careful about that because there's reputational risk. And they're also, frankly, again, they're an officer of the court. Anything they're doing sort of reflects on what the court's doing.
Okay, next question. Are there situations where the bank should clean up a site or remove tanks pre-foreclosure?
Well,
To me, it
there's
depends on
definitely
your appetite
situations.
for risk.
Yeah, and again, the bank probably isn't going to be the one doing the cleanup. We're going to see if a borrower is going to do that to an acceptable standard and see if they're willing to do so. You got to be really careful on how you push a borrower and what you tell a borrower to do. You don't want to look like you're managing the asset, but if they're being copied on reports, it's very likely, especially if the lender pays for it, there's a chance they're going to do it. Now, even that paying for it is taking on a risk. So, it's most likely if there's a significant amount of cleanup, it's something where we're going to look at a note sale or possibly a receivership so that we stay out of that liability chain.
And I can tell you that I had a deal for actually a Texas bank years ago on a gas station property in California where there were all kinds of problems with the property, and we had a receiver appointed, and we had to go back before the judge numerous occasions to get authority to deal with the cleanup, removal of tanks, and so on and so forth. The process ended up taking a couple of years, and during that entire period, the bank never foreclosed. We waited until until everything was cleaned up. We got the letter, signing off on everything, that everything was clean, everything was done, and then we went ahead and foreclosed. And it took a judge that was patient and understood what we were doing. And the bank paid a lot of money to get all that done, but it was a bank that simply did not want to step into the chain of title until they knew that property was clean.
Yeah, and that's what you got to, the careful evaluation of, what is the rest of the condition of the property? How delinquent are the property taxes? How much is this going to cost us to get cleaned up? That's where you may be walking right down the path of let's just sell the note. And is it sometimes that note sale offer is more than you're going to net by the time you pay out all those other problems. I hope that helps.
So next question, I've only got two more. For properties that are destined to be taken into a special purpose entity, what is the liability for the bank if the ERM department obtains phase 1 or 2 bids that will be engaged by an attorney?
Read that whole question again. Would you mind?
For properties that are destined to be taken into a special purpose entity, what is the liability for the bank if the ERM department obtains phase 1 or 2 bids that will be engaged by an attorney?
Well, I would make sure that engagement, let me just say this, I think there's protections for the bank, for the special purpose entity, as long as the limitations of the report allow the lender. I mean, it can be performed for outside counsel, but those limitations and reliance ought to be for, if you engage them correctly, the reports ought to be allow reliance by the lender and the special purpose entity. Whatever's being set up, that's why you need to.
Yeah, and the special purpose entity should be engaging the outside counsel who engages the phase 1 and phase 2. The bank should not be engaging anybody at that point. It all should be shifted to special purpose entity.
So what if they did it, this is me ad-libbing now, what if the bank had already done due diligence before it was realized it needed to go into the special purpose entity?
That shouldn't change anything. They're not in the chain of title.
Yeah, but it's still, you'd still want to get reliance of that report. You'd want to get reliance back to the new LLC, to the special purpose entity, so that with the work that was done for the bank can now be relied upon by that entity.
And is there any particular liability for doing review, for the ERM department doing reviews of reports?
Again, that's not if the bank isn't taking title. The protection of that LLC, and again, we're still probably never going to use an LLC to own something that's a gas station that's got active problems, or even history of problems. I mean, it's still you still want to be careful, even using an LLC.
I mean, essentially, unless there is some way to make, as you're doing all this reviewing, you're doing all this, unless there's some way to have the bank deemed a mortgagee in possession, which is essentially you've stepped into the shoes of your borrower as sort of owning and running that property, even though you haven't foreclosed. Unless you're exercising that type of authority, all the stuff you're doing ahead of time is not something that should create any liability for the bank and in doing your investigation and reviews and things.
Unless you got to be careful with the work. This is where ERM and approving a solid scope of work and I'll say qualified contractors doing the work, is part of the fear is you don't create contamination. If you've got groundwater contamination, you're drilling holes, now you create soil contamination. That's where you got to be really careful for a lender.
Oh, if you've created, if you've added to the problem, then that's a different story.
Right.
Okay, last question, which I think was on the slide, but it didn't get discussed. Is there an obligation to release environmental reports for a foreclosure auction?
No. Let me answer that real quick. No. You know, work done for us, work done for the bank. Going into a public sale, it's buyer beware. And that's true of, you know, interior conditions. You can't go look at. This is why a lot of times foreclosures don't fetch a market price, because they can't get inside. They can't do a full due diligence. We don't have a liability. This counsel, correct me if I'm wrong, but I don't think the bank has a requirement to share our internal report with. Now we may have liability or disclosure issues after we own it, with selling it to a third-party buyer after we own it, but not for a public sale, because we don't own it yet.
A non-judicial foreclosure sale is an as-is, whereas sale.
Yes.
And so once you foreclose and own it, you may have issues down the road as you know, then you're sort of an owner and you kind of got to deal with it. And whatever disclosures you would have to make in any other REO sale, you would have to deal with. The one thing that is a closer call is if prior to the foreclosure sale, your borrower came and asked for a copy of environmental reports or an appraisal. If you have charged those reports and the borrower has paid for them in the past, then there is a possibility the borrower has an entitlement to see those reports. I know for appraisals, certainly if you're charging your borrower for those in California, the borrower is entitled to a copy of it. They've paid for it. And I think it's a similar situation with an environmental report. If they're paying for it, they're generally entitled to see a copy of it.
So what about for note sales? Do reports need to be disclosed for note sales?
That's a great
Typically,
question.
they're asked for. Yeah, in the note sales that we've seen, those are items that are specifically asked for: appraisals and any other reports on the property. And if you're selling the note and you have knowledge of something that's adverse to your loan and you don't disclose it, I think you're buying a lawsuit.
Yeah, we usually make all of those documents available in a list of things that are sort of their due diligence documents that we'll make available to them. Again, it's an as-is, whereas sale, though. I mean, they can review those reports and whatever other documentation you're providing, and they can draw their own conclusions as to what it all means. And we don't rep and warrant anything from those. We say, here you go, you can review them, you can look at them, but you make your own decision. It's an as-is, whereas sale. There are no reps and warranties, and you're getting, whatever we've got, you're getting. And it's your, buyer beware, your risk.
And that's the safest way to do it. Absolutely.
Let me say this, Georgina. We have, on occasion, there may be a case where you engage through counsel, so the counsel is engaging that work, and it may not show up in our due diligence, in the Comerica Bank's due diligence file. You got to be careful with every step of the way here, but that is sometimes a consideration when it's engaged by, the environmental work is engaged by counsel. It's a reason you might do it that way. It's client privilege
that would be
information.
Yeah, that would be a work product, attorney-client privilege type stuff that we would, not be part of it. But if it's just sort of been like, it's just been sort of acquired in the ordinary course of your operations and things, that may be a different story.
Now, internal documents, your ERM reviews, internal documents, emails, that kind of stuff, no, that wouldn't be included. But the base report often is, most of the time is, but it depends on who engaged often.
Yep.
Okay. Well, that's the last question. Thank you.
Yeah, okay. Well, very good. That was a lot of very helpful information, especially when you think about these uncertain times. So I want to thank very much Craig, Chuck, and especially Keith. So point of clarification, I know Keith, but Keith knew the attorneys, so I give Keith a lot of credit for making this happen. So, and especially all those that attended the webinar as well. I hope this was helpful information to everybody. As a reminder, the recording of the presentation will be available on the EBA website in a few days. So please be sure to sign up at the EBA's upcoming virtual conference as well, since it's free to EBA members and available to anybody who wants to join as well. So it's a great time to become a member. Thank you very much, everybody, and stay healthy.
Thank you.
Take care. Thank you.
Bye.